Welcome to Life in Sirens, Behind and on the Scene, a podcast by first responders. We're your hosts, Sophie,
Jamie,
and Aubrey.
The content provided in this podcast is for informational and educational purposes only and should not be considered medical advice. The views and opinions expressed by the hosts and guests are their own and do not necessarily reflect the official policies or positions of any medical institutions, emergency medical services, or healthcare organizations. Patient privacy is a top priority, and all discussions involving real-world emergency situations are de-identified and altered to ensure confidentiality. Always consult with a qualified healthcare professional or your local EMS protocols before making any decisions regarding patient care or medical practices. Listener discretion is advised, as some topics may include discussions of real-world emergency situations.
There are moments in this job when someone speaks to you, and you know. You just know that their words matter. Not just medically, not just emotionally, but legally. Today's episode is about one of those moments. Because what if the things a patient says to you become the very words that decide whether someone spends the rest of their life in prison? This is the story of a dying man in a gas station parking lot. A chaotic scene, a fleeing suspect, and a Supreme Court case that quietly reshaped how the justice system views first responders. This is Michigan versus Bryant. And if you work in EMS, whether you realize it or not, this case applies to you.
We've done true crime before, but this one's different, because this isn't just about what happened, it's about what was said, and more importantly, why it was said.
Most providers never consider that they might become a central figure in a homicide prosecution simply by asking a patient one question: what happened? But on April 29th, 2001, that exact question helped shape constitutional law.
It was just after 3 a.m. in Detroit. Police were dispatched to a gas station after reports of a man shot. When they arrived, they didn't find a controlled scene. They found chaos. A man was lying near the rear of the parking lot, shirt soaked with blood, struggling to breathe, shock already creeping in. His name was Anthony Covington, and he was dying.
Responders approached with intention. No one knew where the shooter was. No one knew if the threat was still active. This is important because your brain works differently when danger is still in the air. An officer asked the question we all ask: what happened? Covington fought for breath and answered, "Rick shot me." Rick. Not a vague description, not uncertainty, a name. He went on to say the shooter was Richard Bryant, and that the shooting had happened at Bryant's house before Covington managed to flee to the gas station. Imagine the physiology in that moment. Massive internal bleeding, likely hypovolemic shock, pain, air hunger, fear. This was not a structured interview. This was a survival speech.
Let's pause here, because every medic listening understands this environment. You are trying to 1. Control hemorrhage, 2. Read mental status, and 3. Determine the mechanism. You're also trying to scan for threats and call for additional resources. And simultaneously, someone is handing you information that could stop a violent suspect from harming someone else. This is not investigation. This is operational survival. Covington was transported. He died hours later. And suddenly, those desperate words became the center of a legal storm.
Bryant was arrested and charged with murder, but the defense raised a constitutional challenge rooted in the Sixth Amendment, the Confrontation Clause. The argument was simple. Covington never testified. Bryant's team never had the opportunity to cross-examine him, so allowing those statements in court would violate his constitutional rights. At first, the courts agreed. The conviction was overturned, but the case didn't end there. It climbed all the way up to the United States Supreme Court.
The court had to answer one question: were Covington's statements testimonial or non-testimonial? Because that distinction determines whether a statement can legally replace live courtroom testimony. To understand this, we have to briefly step back to another case, Davis v. Washington. That case introduced something called the primary purpose test, which asks, why was the statement made at that exact moment? Was it to build a criminal case, or was it to resolve an ongoing emergency? Intent matters. Context matters. Timing. It all matters.
In a landmark ruling, the court determined that Covington's statements were non-testimonial. They were admissible. Why? Because the emergency was still unfolding. The shooter was unaccounted for, the location was unclear, the risk to the public and to the responders was real. The court recognized something profound. People who are trying not to die are not thinking about courtrooms. They are thinking about survival, and the responders speaking to them are not acting as investigators. They are acting as protectors.
Here is why this case matters so deeply for our profession. For the first time, the court explicitly acknowledged that first responders, not just police, operate inside active emergencies, which means the questions we ask are fundamentally different from interrogation. We ask to treat, we ask to protect, we ask to understand risk. And because of that, statements made to us may carry legal weight, even if the patient never speaks again. Let that settle for a moment.
You've probably heard patients say things like, he stabbed me, my boyfriend shot me, she poisoned me. And maybe you documented it, maybe you didn't, but understand this. Your chart may one day speak in a courtroom when your patient cannot.
The court emphasized factors that every experienced medic intuitively evaluates. Was the scene secure? Was the suspect still a threat? Was the patient unstable? Was the information necessary for immediate decision making? Your documentation answers those questions, sometimes years later, without you ever even realizing it.
Let me say something that might permanently change how you write narratives. You are not documenting for court, but court may rely on what you document. There is a difference. In this case, responders never said, "We are conducting an interview." They were trying to figure out what just happened in order to keep everyone alive. That framing protected the admissibility of the statements. Not because anyone planned it, but because it was authentic to the emergency. Your tone matters, your wording matters, your intent matters. Write what you heard, write the patient's words, and if you do, use quotation marks. Avoid interpretation, avoid summary, capture reality, because memory fades, but documentation is forever.
All testimony is evidence, but not all evidence is testimony. Testimony is powerful and dangerous because it replaces a live witness, which is why courts restrict it so heavily. But emergency statements are different. They're not structured, not manipulative, not designed to persuade a jury. They arise from chaos, and the law recognizes that.
The court essentially said this: if the government intentionally creates testimony, the accused deserves confrontation. But if statements emerge naturally during an emergency, they are not substitutes for testimony. They are reality captured in motion. That distinction protects both justice and responders.
You may think this is theoretical. It isn't. Cases across the country continue to rely on first responder documentation in homicides, domestic violence deaths, officer-involved shootings, pre-hospital death investigations, and we've seen modern trials where EMS recollection became controversial because documentation lacked specificity. When you write it down, you don't have to rely on memory years later under oath. You simply tell the truth, supported by the record you created minutes after the call. That is protection for you, the patient, the system.
One of the biggest cases that was publicized was the Karen Reed trial.
I was just thinking about the Karen Reed trial.
Mm-hmm. And in the Karen Reed trial, on scene with the victim, responders reported, a couple of the fire medics reported that they heard Karen Reed say, "I killed him, I killed him, I killed him." Normally, that would be considered testimony. Whatever it is that they brought into the courtroom, the responders would be considered testimony. However, because it was unfolding in an emergency situation and it was it was uncoerced. It was not prompted. It's not testimony. It's basically just a part of the evidence.
Yep.
And that is a perfect example of how that unfolds. It may not even be your patient.
Yeah.
You know, it could be a bystander. It could be, but things that could potentially be of evidentiary value that basically you're going to get drug into anyway.
Yep.
Document it well so that you don't misremember.
Yeah.
So let's circle back and bring this all back to medicine. Because at the center of this case is a critically injured trauma patient. Gunshot wound to the abdomen, high mortality mechanism, likely internal hemorrhage, rapid shock progression, altered perfusion affects cognition. Yet many trauma patients remain lucid long enough to communicate essential facts. Those minutes matter medically, and sometimes historically.
Here is a sentence I want every provider to remember. You are almost always operating in non-testimonial space. You are there during instability. Your communication is functional, not forensic. But that does not make it insignificant. It makes it powerful.
There is something sacred about being present for someone's final words. Not sacred in a dramatic way, but sacred in a responsibility way. Because patients trust us with their truth in the most unguarded moments of their lives. And sometimes, justice listens through us. So ask the questions you need to ask. Treat the life in front of you. Protect the scene. Document what you hear. And never forget, in this profession, even words can echo long after the call. So let's talk about it.
I think that we've talked about this extensively on this show before. We have a couple episodes talking about documentation and the pros and the cons of what you can and can't put in there. I know a lot of people, we hear this pretty frequently of like, well, I'm not going to put that in there because I don't want to go to court.
You're still probably going to go to court.
Yes, you are still. If it is something that is inherently going to go to court, gunshot wounds, a MVC with a fatality, something like that, I'm so sorry to tell you, you already are going to go to court. So how much do you want to be able to remember when you're on that stand as a witness?
Or your
Mhm.
documentation is so good that you don't have to go to court.
That you don't have to go to
That is
court.
very true.
And I've been called or subpoenaed on a handful of times. And when you go in there, the reason that you are a useful witness to subpoena is because you operate in this non-testimonial space. So statements that your patient made to you, statements that bystanders made to you during the scene, it is very useful to the prosecution if the statements they made to you are useful.
Yeah.
But when you document your run ticket, just remember that everything that happened on that scene is something that you were privy to. Now, do you document every single moment of every single second of that scene? No. But if you neglect to document large, scathing statements that were made in your presence, what does that do? What good does that do, and for who does it do it? So are you really protecting a victim, or are you protecting yourself?
Mm-hmm.
Are you really concerned about the optics of you documenting that, or are you concerned that you might have to spend an afternoon in court? And when we think about our job, and the point is when everyone gets into this job and they do their first ever interview, they say, I just want to help people. And I'm like,
Just wanna
if
make a
you
difference.
document the reality of the scene that you were on, you may have the opportunity to do just that in a job where we don't often get to do what we thought we were going to do.
Yeah.
And it's still your choice. It's still your
Yeah.
choice whether you document statements or you document things that people said.
And you don't have to like be bending over backwards trying to be like, oh my gosh, what did they say? If you remember exactly what they said.
Yes, if your patient looks at you in your eyeballs and say, Janice stabbed me with my own kitchen knife,
I'm going to put that down.
man, sorry.
It might be worth writing down.
Sorry about
Okay.
Janice.
I know that you guys can't see this because we're not doing video recording, but Aubrey and Jamie literally just made the same, like in unison, they did like, what is it even called? They like shrugged their shoulders and like put their hands up, and it was very funny. But when we were like, if you hear them,
Sorry
say
about it.
So I think a lot of people too say they've been taught not to document quotations.
Yeah.
I think that's weird.
I hear that a lot.
I would challenge you to go listen to the Standard of Care podcast because the people who host it, one is a paramedic, one is a lawyer, and they are much more experienced than we are with this. So if you don't believe us, go listen to them, because Sam, the lawyer that hosts that show, she talks
Shout out
about
to
this.
Sam. We
Shout out to
love
Sam.
you.
She talks about using document or quotes in documentation, and she gives it the green light. So if you don't believe us, go listen to her.
Yes.
Yeah.
She is literally an expert in the field. She works
Absolutely.
for a healthcare company and works very closely with EMS.
Yes, that is her job,
Yes.
is making sure that EMS staff understands the legality of their job.
Yep.
I would also argue, or I guess just make a point, that like nobody is asking you to put in quotes the patient's dissertation.
Right. Or
Like it's if
not.
they make a very like pretty simple statement that can be easily remembered and documented. If you cannot remember exactly what your patient said, don't write it down.
Yeah.
Don't put it in quotes.
Yep.
Yeah.
You know, and so I think that that's important to remember.
Yeah, and again, we've said this before, especially if you've seen any of our scene to subpoena or presentations or listened to any of our scene to subpoena episodes. Sorry. It's late. My brain's not working. But we talk about this a lot. Your job is clinician first, right? Be a clinician, take care of your patients.
Take care of your parents.
they're-
They're elderly.
It's definitely possible. Make sure you're taking care of everybody. You're a provider first. You're not an investigator. But if you happen to hear something like James said, that is explicit, and you can remember it when you have completed the call and you go back and you're like, dang, that really stuck with me. That's the kind of stuff that we were talking about, and that was
Absolutely.
what happened here.
Yeah. The point of this episode is not to empower people to conduct interrogations in the back of their
Right.
ambulance. The point of this episode is
Arguably, then it would be in testimonial.
as
Yep.
well. See, there y'all are getting caught up in some legal mumbo jumbo
Mhm.
already. So don't do that. The point of this episode is to help you realize how impactful your documentation can be in the legality side of things way after the call is finished. So again, what we're asking you to do, we're not saying that if somebody, you say who shot you and they turn their eyes to the left and look upward, that you document that. We're saying if they make an egregious statement that you can recall word for word, put it in your narrative, because you have no idea the effect that can have down the road.
Yeah, and how incredible
Mhm.
would it be, like, you're the reason someone got justice because they could no longer speak for themselves,
Correct.
like in this case. So,
Absolutely.
Um,
I think documenting last words can be useful in many different facets, whether it's to family or whether it's to law enforcement or whether it's to the providers of the hospital, like whatever it is. I don't think that if you just pick up like a granny with belly pain who is like confessing her deepest, darkest secrets to you,
yeah.
that maybe that's the time and the place.
Yeah, I know. Like, if there's an active threat that is the crime scene is here
Yes.
right now.
Yes, and that really is what this hinges on, is that because it is an active scene, there is a safety threat, your patient is actively dying, that's what makes it an emergency statement and a non-testimonial.
Absolutely.
And so outside of those circumstances, it may not be considered the same in court.
I know that we are not trained in legal things, so I just wanted to recap the difference between non-testimonial and testimonial, if y'all are good with that.
Yeah.
So a non-testimonial statement, so these are statements made during an ongoing emergency, primarily to resolve a medical or safety situation. So the case we talked about, there was an active shooter or someone who had not been detained yet, who potentially caused a threat, and that person was named by the patient. So courts generally consider these admissible, even if the patient later cannot testify, just like in this case. So again, made in an active emergency. They're intended to guide treatment or protect safety. They're not primarily made for criminal investigations, and they're usually spontaneous, right? The patient just says it, or you say like, what's going on, and they just tell you everything. You didn't say who shot you, or whatever. You're not, which we could ask that, I suppose, but
Yeah.
the cop can't ask that. And
True. And in some scenarios, the cop even can if it's to resolve a safety
emergency,
concern, to resolve the
right.
emergency.
So, moving on to the testimonial statement. The testimonial statements are those that are primarily there to establish facts for prosecution rather than resolve an emergency. So these statements are typically requiring the person who made them to testify or to like formally give a statement, unless there's some weird exception, and apparently there are exceptions, but I did not dive into that because I don't know a lot about law. I'm just gonna
set that up.
That's your warning.
I'm not a lawyer.
I'm not a lawyer. Nor do I probably have the patience in me to be one. Or just like the confrontational. But honestly, Sam is not a confrontational.
I know, but she does such a good job.
She's not a criminal
sweet
prosecutor.
That's true. Okay. So the characteristics of testimonial statements are going to be they were made after the emergency was stabilized, right? So there's not an active scene. And they primarily are there to investigate, and they are structured questioning. So they are intended to establish past facts or for legal proceedings or things like that. So they would be like pointed questions. Who assaulted you? Where exactly did they hit you? What weapon did they use? In a formal setting.
Yes. And like I think that a good example with this case, if this individual went to the hospital, was stabilized, it was a couple days later, they managed to figure out who they believe shot him, apprehended the suspect, and then an officer or detective came to do an interview with this patient, that's testimony.
That would be the actual formal interaction.
Yeah.
Key legal cases, other than, so we were talking about Michigan versus Bryant, where it was clarified ongoing emergency doctrine, and there's also Davis versus Washington, which we briefly mentioned, which distinguished emergency versus investigative questioning. And then there's also Crawford versus Washington, which established the modern Confrontation Clause standard, which we talked about at the beginning of the episode.
Yeah, where you can face your accuser. Yeah.
Alright, do you guys have anything else to say?
No, I just think remember when you're documenting that the chance of you being subpoenaed for that call and ending up in a courtroom is already probably pretty substantial.
Yeah.
And so document things well and honestly, so that way when you do stand up there and have to answer this questioning from the prosecution or defense or both, that you are able to have a good, solid recollection of what you experienced that evening or afternoon or morning, and you're able to do our job and your service and everybody involved justice because you documented well.
Absolutely.
I think as long as you remember that, and that's your goal, is to make sure that you cover your own bases and you are competent and you do that with integrity, you'll be in the clear.
Absolutely.
I think one of the biggest responsibilities as pre-hospital providers, we have as pre-hospital providers is patient advocacy, and this is a way to advocate for your patient way beyond the field.
Yep, and that is your duty. So at the end of the day, remember, EMS providers are not investigators, we are clinicians. But the words spoken during emergencies often become a part of legal record. Understanding the difference between testimonial and non-testimonial statements helps us do two things well. First, it helps us focus on what matters most, patient care. And second, it helps us ensure that when our documentation is used in court, it accurately reflects the medical reality of what happened on scene. Because sometimes the words spoken in the back of the ambulance eventually become evidence. If this episode brought you value, take a moment to rate and review the show. It helps more providers find us. Follow Life in Sirens, join our mailing list for exclusive content, and visit lifeinsirenspodcast.com for resources and downloadables built for the modern provider. And if this conversation made you think, send it to your partner, your preceptee, or someone on your crew, because better providers build better systems.
This has been Life in Sirens, produced by 3 nerds trying to bring you content that you might actually care about.